Hello everyone, welcome to Analog IAS. In this video, we'll be discussing about the jurisdiction and the powers of Supreme Court of India. The Constitution of India has given wide powers to the Supreme Court in terms of the jurisdiction, while some of the provisions are explicitly mentioned in the Constitution, while others such as judicial review are implicitly mentioned in some of the articles like Article 13, etc. Therefore, the first point is the original jurisdiction of the Supreme Court. It deals mainly with if there is a dispute between center on the one hand and one or more states on the other hand, or if there is a dispute between the center versus any state or states on the one side and one or more states on the other side, or between two or more states, then the Supreme Court of India has the original and exclusive jurisdiction. That is, no other court in India can accept a suit in case of federal dispute. While in the case of guaranteeing the fundamental rights to the citizens of India, it has original jurisdiction. That is, if a person feels that his fundamental right has been violated, then he can approach Supreme Court directly and not any other court. The second point is the appeal by the special leave. This is one of the discretionary powers which are given to the Supreme Court, where it is authorized to grant in its discretion special leave to appeal from any judgment in any matter passed by any court or tribunal in the country. This special leave cannot be extended in the case of military tribunal or the court martial. Therefore, matters concerning regarding the military tribunals cannot be accepted by the Supreme Court through the procedure of special leave. Rather, it can take up the case through other procedures. The next point is the advisory jurisdiction of the Supreme Court. Article 143 of the Indian Constitution authorized the President to seek the opinion of the Supreme Court in either two cases. One, on a question of law or a fact of public importance that has arisen or which may likely to be arised in the future, or any dispute arising out of any pre-constitution treaty, agreement, covenant, etc. While in the first case, that is in the case of question of law or fact, the discretion is with the Supreme Court whether to give the advice or not. While in the case of second case, that is dispute arising out of any pre-constitution treaty, the Supreme Court must tender its advice when the President requests so. The advice given by the Supreme Court in case of advisory jurisdiction is not binding on the President, while it is only advisory in nature. The fourth point is that the Supreme Court acts as a court of record. That is, its judgments, proceedings and acts of the Supreme Court are recorded for perpetual memory and testimony, and they are admitted to be of evidentiary value and cannot be questioned before any other court. It also has the power to punish for the contempt of the court of itself or any other person. The contempt of court can be either civil or criminal. Civil contempt means willful disobedience to any judgment given by the court or willful breach of an undertaking given to a court, while that of a criminal breach of contempt of court is when any person scandalizes or lowers the authority of the court or interferes or obstructs the administration of justice in any other manner. Then the Supreme Court can hold that person responsible for the contempt of court. The last important power of the Supreme Court is the power of judicial review. Though Article 13 implicitly provides this power to the Supreme Court, it plays a very important role in the democracy of India, where the judicial review is the power of the Supreme Court to examine the constitutionality of legislative enactments and the executive orders of both the central and state government. That is, if a Supreme Court finds faults in the acts that are done by the legislature or the state parliament, then the Supreme Court is well within its limit to nullify the acts or orders that are given by them. Now let us solve this question. Consider the following statements. Judicial review is explicitly mentioned in the Indian Constitution. The advice tendered by the Supreme Court in case of advisory jurisdiction is binding on the President. The correct answer is D, none. As we have just discussed that judicial review is not explicitly mentioned, rather it is mentioned implicitly in the Constitution through various provisions. While the second statement is also wrong because the advice tendered is not binding, rather it is only advisory in nature. Therefore, the correct answer is D, none. Thank you.